Let's see if we can get this. All right, let me try this again. Thanks for all your support and giving me the ability to bring credible information to you day in and day out. I really appreciate it. Without your support at selfgovernanceu.com and all the contributing members that join classes and help support and fund uh, this presentation, none of this would be possible. So just wanted to take the time to say thank you. This is a short little ditty. It's probably going to come in 2 or 3 parts. I've decided to go ahead and go through the whole thing instead of just the 60 points. And this is just kind of a refresher or good clarifying points to make in a court case. And so I wanted to bring this to you for your viewing and listening pleasure. I know that your day-to-day life causes you to constantly be active and on the go, whether taking your offspring to baseball practice, baseball games, football, soccer, the whole 9 yards. I know that many of you don't have time to sit down and read, so I make these short little videos for you to ascend of the mind and to look at things from a different perspective. So with that, I thank you for your time, and I hope that you enjoy these short video audios that I post on YouTube here for, again, your convenience. Note, only ask questions, request permission back to the judge. Say, for the record, may I ask if judge sustains any objection, object. Okay, and you're going to object and take exception to the fact that they're objecting. And ask, is your honor trying to limit my defense? Ask based on what fact or law, or you can simply ask, don't I have a right to a fair and meaningful hearing? Don't I have a right to full disclosure to understand the nature and the cause of the alleged allegations? Okay. If judge says it's beyond the scope, ask, what is this all about? 60 ways to shut down a court case. Clarify. Points of order or points of clarification. Select and use any of these points at your own risk upon your own case and research. All right, so don't just blindly use these. Understand them. Seek to ascend of the mind and comprehend who you are, what's going on around you, and how it applies to you. And if you don't know, ask. And if at first you don't succeed, try again. You know, being involved in many of court cases, I've come to realize that we always want to set up a perfect affirmative defense for an appeal. And if we don't do that, we fail to set a proper record and set the appeals record for the appellate brief. If we don't do that by reserving our rights and objecting timely and taking exception to it as an appealable issue and noting it on the record, so often we fail. And we don't just fail ourselves, but we fail our fellow countrymen. Remember, when we prevail, the people prevail. Okay, so keep that in mind. This is written in a way that it's kind of hard for me to read because my brain is trying to process ahead of the written instrument here, and it's not always written in a fashion that my brain processes quickly. So if I stutter my way through this and stammer through it, please forgive me. Is this a court of record, of competent jurisdiction? And that question is very important because we want to know that this is a court of record, all right? Is this a judicial proceeding or an administrative proceeding, all right? There's different rules to judicial proceedings versus administrative proceedings. If no, what are you convening? What venue is this? All right, where are we at? Are we in legal land where Puff the Magic Dragon can come in and blow on Jackie Draper's ear and create Jackie Paper? Are we in reality or are we in fiction? Okay. What is your jurisdiction? Aren't there 2 types, personam and subject matter? Okay. And we want to know if we're in concurrent jurisdiction, auxiliary, or exclusive. Are they blending all three under the Judicature Act of 1875? Now, this might be a little advanced for most people, but these are all relevant points and questions to ask. And if you ask this series of questions before you get started, the chances are that you're going to receive something in the mail that says the sua sponte, upon the decision of the court, the state has not met its burden of proof to proceed, and therefore this court dismisses said action. Okay. And remember, by asking these questions, we can expose the truth by their admission by omission, their failure to clarify, their failure to accurately record on the record what's true, correct, accurate, not misleading. By asking the questions, the devilish tricks of the lawyer go out the window. 3, judge, is your oath of office a contract? Yes or no? Okay, I always tell people you've got to accept the oath of office because it is a contract. At the time, it's a contract that they have entered into, as equity imputes an intention to fulfill an obligation. However, equity will not perfect an imperfect gift, meaning that if you don't acknowledge and accept their oath of office, it's an open-ended contract. And if you haven't accepted and acknowledged it, then it doesn't apply. So make sure, for and on the official record, in a judicial notice or orally, that you accept and acknowledge the oath of office of the judge. How many oaths of office are there? There are a multitude of oaths of office. There is the Title IV 101 oath of office. There is the Title V 3331 oath of office, which is their private for-profit oath of office, where they're operating in Admiralty Maritime under the UCC to negotiate securities, financial instruments, okay? So I accept and acknowledge that as well. There is the Title 28 455 oath, 453 oath of office, and I accept and I acknowledge that one as well, okay? Then there is the constitutional oath of office pursuant to the Constitution for the United States of America. I accept that as well. And then there is the state constitutional oath, and I accept that as well, okay? So we want to make sure in a judicial notice that we accept and acknowledge all of those oaths of office, and I go as far as to pull them up, and I supplant their full legal name, if I can find it, anywhere on public record. I supplant their full legal name in the section where it says IAB, which is where their name is supposed to go. And I put them on judicial notice of the acknowledgement and acceptance of that oath of office, and I bind them thereto to protect my unlimited, indefeasible, unalienable rights, both written and unwritten, okay? I don't see where the person administrating your oath had an oath on file and or recorded and filed his copy of your oath. It is incumbent upon you, ladies and gentlemen, to ensure that you demand their oath of office be put on record for your inspection, not just filed in the case file jacket. There's this egregious misconception that if a document has been filed with the clerk of the court, that it is on the court record, okay? You want to get it recorded onto the court record for your inspection, all right? And if the oath is not proper, well, then there isn't an oath. Now, people say, well, how do you hold them accountable? I use the maxims in equity to hold them accountable. Equity imputes an intention to fulfill an obligation, meaning that the second they received a paycheck, they were bound by the intent of the organic constitution and the oath prescribed that they are supposed to have, okay? And so I bind them in that manner. And remember, if you fail to acknowledge and accept their oath of office, and in doing so, equity will not fulfill an imperfect, or equity will not perfect an imperfect gift. All right, so you have to acknowledge and accept. Number 4, judge, why don't I find a bond? We require their good faith bond be placed on the record for, again, our inspection. Okay, they don't have their bond on record for our inspection. It is as though it doesn't exist. Remember, this is a very controlled environment, and we want to keep everything that gets put on the record very sanitary and clean like for our inspection purposes. Okay, we're not qualifying their bond, it's for our inspection purposes. The bond is going to tell us who the surety is, who the principal is. It's also going to give us a plethora of information on how to contact the managing agent of the bond so we can make a claim. Okay, a bond is just a fancy word for insurance. Okay, who is your insurer? A lot of times it will be different companies, mostly I find that are out of Delaware. Like, for example, the Ohio Insurance Company sounds like it would be located in the state of Ohio. However, upon further inspection, Ohio Insurance Company is actually out of Delaware. 5. Did the judge sign the correct oath, not impartial? File his oath into the case. Again, if you can't get them to provide their oath of office freely of their own free will and volition, which is kind of deceptive, what you can do is you can hit the judge with a FOIA, okay? Freedom of Information Act. You can hit the clerk of the court, the secretary of state. In every state, it's a little different. They do this intentionally to cause mass confusion. So people don't necessarily know where to find them. Sometimes you find the judge's oath at the county recorder's office. In other states, you will find that the clerk of the court has them. In some states, you will find that the secretary of state has the judge's oath of office. All right? We want to pay peculiar attention to all documents. We want to make sure that everybody is using their full legal name to sign the oath, okay? And that they're not using a pseudo name. And if they are using a pseudo name, for example, first name, middle initial, last name, then we want to make sure that on the county record, they have that assumed business name or trade name filed on record. And you can find that at the county recorder's office or the secretary of state's office. If you can't find them in either location, you need to put the judge on notice, or anybody for that matter using a false and fictitious assumed unregistered business name that you cannot locate. You want to put them on notice that you demand they produce said assumed business name or trade name for and on the official record for your inspection. This is about holding people accountable and liable for their actions and making sure that you can be compensated for their unjust enrichment or engaging in simulated legal processes using sham legal pleadings without being able to provide a bill of particulars as to the nature and cause of action that they're attempting to subject you to. Okay? 6, judge, is your oath I have here, did you swear an oath to uphold the Constitution? Which ones? Now, the reason they ask for which ones is after the Act of 1871, there are 2 jurisdictions running concurrently at all times. You have the de jure, and then you have the de facto. And it's important to understand that there are a multitude of constitutions out there. Michigan, probably one of the most confusing states that I've ever evaluated. And in Michigan, I think if my recollection serves me proper, they have altered, flat out created a brand new constitution at one point. I think over 6 or 7 constitutions have been manufactured, and it's always funny because they say by the consent of the people, the Constitution has been amended, but they didn't amend it. They just flat out rewrote it, which I found extraordinarily interesting, and asked the people of Michigan, when were you ever asked whether or not you would allow them to just rewrite the Constitution and bind you to it? So you have to invoke the proper Constitution, which is the organic constitution in each state. You invoke it. You invoke your unalienable rights. You invoke the Bill of Rights. You invoke, if you so choose, the law of nations. And you bind these people to it. All right? 7, will you, judge, sign any contract that guarantees that you will protect all my unalienable rights that are protected by this country's Constitution and in this instance, Washington State's constitutions. Okay. And again, you're going back to the two constitutions of Washington State. You see one here clearly at 1878 and 1889. Again, I like going with the organic constitution, with the meat and the substance on the bone still. All right. The intent of the testators, because all constitutions are, in fact, trusts. Okay. And to prove that, you just simply have to read the preamble. All right. 8. Do you intend to process this case according to the Constitution? All right. And when we ask questions, we just want to ask one simple question, get it on the record, make the observation on the record as to the answer. If the answer is not sufficient, we're going to ask for clarification and get them to explain further finding of facts and conclusions of law on the record to ensure that all real parties in interest are fully informed, pursuant to due process of law. They're going to get very annoyed about this because they like to run sheep through their little fucking chutes and run them through as they wager on the ignorance of the people. So they're going to get very hostile, very annoyed. And if they are starting to yell and stammer around like the little devils they are, it's always a good thing to put on the record. Is there a reason you're being hostile today, Your Honor? Is there a reason you're yelling at me? Is there a reason you're scolding me? This seems like it possibly could be contrived to be seditious behavior or behavior unbecoming of a judge that might lead to insurrection. Is there a reason that you're hostile today? And by asking these questions, okay, you will notice the demeanor of the people sitting on the bench will change very, very quickly. And I speak with firsthand perfected knowledge of these facts. I am very, very good at calling them out on their bullshit. When you're in a court, it's very important to think of yourself like a radio announcer announcing a baseball game. You see, if the radio announcer was very dry, he might just continue to report to you the score. It is now 2-1. It is now 3-1. It is now 4-1. But a good announcer makes you feel like you're right there watching the game. All right? And so I want you to be able to put yourself in a mindset in a court where you're announcing on the radio the game at play. You're announcing the emotion, the actions that are happening, the yelling and the stammering of the crowd, and the crowd erupts with glee, and so you want to be able to put yourself in that mindset of being a radio show host, charged with the duty of making sure your audience and listeners are feeling as though they are actually at the game, okay? And what this does is it allows the appellate court to review things, such as unbecoming behavior of a judge. You see, because the stenographer doesn't type in any of her or his opinions as to yelling or the gesturing of shaking of the fist or pointing at somebody, which is all unbecoming of anybody in a court. So it's very important to understand that you must audibly express what is transpiring in the room. And the judge began to yell, all right? And because you're yelling, am I to interpret your aggression as being hostile towards me? Have I done something wrong? And you'll notice really quickly that by getting that stuff on the record, by getting that stuff in the transcript, now it's easier to have a judicial review board look at the conduct that was exhibited, that was noted by you and the stenographer. And of course, you always want to have 2 or more witnesses with you. And this is how, ladies and gentlemen, you effectually stand up for not just yourself, but all the people in the community that you're at, and help them take notice and gain an understanding of how this is done. So, do you intend to process this case according to the laws of this state? Well, the law of the land is the Constitution for the state, okay? Do you intend to process this case according to the UCC? Again, if they're going to operate by the UCC, ladies and gentlemen, is a uniform commercial code. If it was the law, it would say it's the law. It says it's the uniform commercial code. And if they're operating by the uniform commercial code, contract creates the law, equity follows the law, and all they're attempting to do is usurp your exemption to access the account that was bequeathed upon you out of the law of necessity and trust law when they removed Article 1, Section 10, or stopped enforcing Article 1, Section 10 by the abrogation of the Gold Clause in 1933. So, as you know, all alleged crimes, and I say alleged because everything is civil in nature, there's a presumption of a civil contract that we're all under. As you know, with this presumption of the civil contract, all crimes are actually commercial, and it's evidenced in 27 Code of Federal Regulations 72.11, where it says that rape, sodomy, larceny, money laundering, all of that is civil, ladies and gentlemen. A real criminal action pursuant to the Fourth Amendment would be, the evidence would be submitted to a grand jury, and the grand jury would decide whether or not there's grounds for an indictment. An indictment is a true bill, ladies and gentlemen. And there are rules and regulations to getting that grand jury indictment. And then, of course, you would be prosecuted based upon whether or not a grand jury or petite jury had decided that there was enough factual evidence of intent, ill will, malice, malfeasance to cause harm, damage, injury, and loss, and believes the state has the ability to prove its burden, and as such, grants the authority to move forward. Very rarely have I ever seen a true bill owing a grand jury indictment that hasn't been tampered with in the execution process of acquiring the grand jury's consent to prosecute, because most often the alleged prosecutor has firsthand contact with the jury, the grand jury, and can influence them. So a lot of times the adversaries, they're agitating the issue and pushing upon them their beliefs in order to get them to agree with his assessment and to convince them that he can win this egregious wagering he's about to do. All right, so moving on. Number 9, Judge, how can I know that you are being honest and adhering to the law? It's a great question. Let him explain that to you. All right. If you are being deceitful, how do I know? How can I know whether or not you are being deceitful? This is a great question, and the reason for that is under maritime admiralty law and under the law of military occupation, the judge from the bench is allowed to lie to you because he's just an administrator administering a bankruptcy. He's allowed to lie to you. And if you don't know your rights, ladies and gentlemen, let me be very clear. You don't fucking have any. All right? And I know this with firsthand perfected knowledge. Okay? It's taken a long time to ascend to the mind and get where I'm at. And I don't know everything there is to know. And I will be the first one to tell you that I don't know everything there is to know. I constantly am learning. I am a student of the law, both the law created by man, or the perception of law created by man, and nature's God, natural law, the law of nature. Okay? Two different perspectives and realms, mind you, two different jurisdictions. All right, we have the fictional realm, and then we have the realm of reality. 10, Judge, do you have the full judicial power of the state? Okay, this is kind of a loaded question. And depending on their answer, you will either note an objection on the record, or you can ask another question to get more clarity. A point of clarification to further comprehend and understand what you just stated. And you may reiterate what they stated to make sure that you understand the words that came out of his mouth, or that you're recognizing them, and then ask another following question. Or is it the military power? Okay. After the War of 1812, there was a declaration of war, but no proclamation or treaty to end it. Okay, and we want to ask about that, or we may want to subpoena that information to see if it exists, that a proclamation or treaty ended the war. All right. And it's clearly evidenced by the Lieber Code and the surrounding actions that are being taken by all these administrative courts. Remember, a judge does not administer the alleged law through statutes, codes, city ordinances, rules, and regulations, but by sound doctrines, principle, and reason, a good judge makes a decision. And so if they're using statutes, codes, city ordinances, rules, and regulations, well, we know that you're in a military administrative procedure. 11, may I request, and a wish is actually a command, an affidavit that the judge has no bias, no conflict of interest, no interest in the outcome of the case. This is very important because everything is presumed and assumed in administrative procedures, and so instead of assuming and presuming, making an ass out of you and me, we require that an oath of a testimony in the form of an affidavit under draught is put on record for our inspection, that the alleged judge has no bias, no conflict of interest, and no interest in the outcome of the case, whether financial or otherwise. All right? They will never, ever, ever do that. Ever. Because it would just be a bold-faced lie that they could be held accountable for. Because again, in the administrative side of the court, it's always for profit and gain. The penal code has penal bonds and penal sums attached to it, and they get a little snip, a piece of the pie, all right? And that's why they're required to file 1099-Rs to the IRS to show what bit or portion of the case of the financial wherewithal gained went to their retirement fund. If no, may the record reflect that the judge has. 12. Judge, may I hold you as surety so that I will not be damaged by any of your undisclosed presumptions, nor by my ignorance of any written and unwritten law, facts, or presumptions in this case. If no, ask, may I let the record show that the judge will not be held as surety. 13. May I see an affidavit from this judge describing the nature and authority of this court, the nature and cause. All right, we're asking for him of his own free will and volition to put testimony in the form of an affidavit showing how the court has jurisdiction. For example, a verifiable pleading has been placed before the court, sworn to under the pains and penalties of perjury under jurat. The statements of fact are alleged and allonged under the pains and penalties of perjury to the claim or verifiable complaint, that an affidavit in support of the statement of facts and claim is in fact allonged to the verifiable complaint or claim, and that the statement of facts is to allonged to the verifiable complaint or claim, and an affidavit in support of that complaint, claim with statement of facts is in fact allonged under the pains and penalties of perjury to the verifiable criminal complaint or claim. Okay? And by doing so, this court here does have jurisdiction pursuant to, and then they go into the finding of facts and conclusion of law, right? And so we're looking to see how this court has jurisdiction. They may even go into the territorial explanation as to why they have jurisdiction, or the contract that grants rise to them having jurisdiction. All right. All of these are options, but the chance of them doing this for you is none. They're never going to. They won't. They will say they have jurisdiction. They will tell you that, but they will never show you that they have it. And if you're dumb enough to fucking believe them, well, guess what? They're intelligent enough to sell your ass down the river, down the banks. Remember, a judge sitting on a bench is nothing more than a banker sitting at a bank. Period. 13. May I see an affidavit from this judge describing the nature and authority of this court? Now, remember, there's another way of challenging the issue before the court as well, and that's going to be challenging the prosecutor for his authority to even be in the room. Okay, where is your claimant? Where is the claimant making a verified claim sworn to independently bonding this case? If he doesn't present himself before this court, one can presume and assume that he doesn't exist. All right? I see no facts and evidence to the contrary. Make it a point of law and make them drag their happy-ass fucking clients into the courtroom for your viewing inspection. All right? Make sure they got a pulse. Okay? 14. Does any part of the fine I might pay go into the judge's pension fund? Remember when I was articulating to you about the 1099-R, okay? And the answer to that is yes. But although I know these things, I still have to be able to prove them. So a FOIA is always a nice option of being able to drag out the truth, okay? Is judge a party to the action? Yes or no? Okay. Does he have a conflict of interest? That's Title 28, United States Code 455. That's how you disqualify the judges. And I can honestly tell you, in all jurisdictions, I can disqualify every last one of the alleged judges. There are a number of things that they do that are absolutely insidious, they're improper, and they could be removed for it. And every last one of them doesn't. Are you judge under IRS criminal investigation? That's just a polite way of shooting a warning shot across the bow if you know anything about the Internal Revenue Code, because don't we all wish to be in voluntary compliance with the Internal Revenue Code? That's a good one. Causes them to shit their chonies. Skid marks are left in their underwear after asking them something like that. Do you have a driver's license, a social security number? If they are honest about these things, they have to recuse themselves. You can also ask them, what their nationality is, if they have a status of citizenship and what it is. Okay? 16. Does it not appear that plaintiff state hasn't yet exhausted all of its remedies in commerce, due process of law, before they parade you around in the public? When did they give you proper notice and opportunity to remedy the situation, if there was any actual harm, damage, loss, injury, or hardship caused by your actions, whether knowingly, willingly, intentionally, or by mistake? When were you given due process of law? I need to see it entered onto the record so I can see the process for which was due to me prior to them parading my good name in the court system and violating my unalienable rights to protect and defend my reputation. My reputation is an intangible right, okay, that I have a right to protect. They should not be going around slandering and defaming my good name. Woe unto ye lawyers, right? Okay, pay attention to that. Okay, one of the commandments, thou shalt not bear false witness against his fellow brothers and sisters. What are they doing by falsifying a record and slandering and defaming your character, which you have a right to? 17. How can I understand? How can I recall, as I don't remember, a casual occurrence? 18. Could you repeat, rephrase, break down, simplify, explain that question? this is a nice way of taking them off of their script and making them break down even further their pseudo claim, right? We want to dissect it with a scalpel and not use a hatchet. This requires skillful questions to be asked to peel back the onion and the layers of deceit. Okay, because it's there. All we've got to do is ask the right questions and get it noted on the record, their answer and their response, and whether or not we accept or take exception to their example, if they can qualify their answer by supporting facts and evidence onto the record for your viewing pleasure. So you can ascend of the mind, right? Because the court should be a place where people ascend of the mind, not a place of folly and deception to unjustly enrich themselves. It should be a place where we can all go to ascend of the mind so we can be more true to the law, right? This is why Jesus was flipping over the tables, because they had turned his father's house into a whorehouse. All right. They had turned it into the money changer's house of deceit and deception. So he went in there and kicked a little ass. Amen. Okay. Speak more slowly. Do not allow these people to run roughshod over your back at 1,000 miles an hour like you're at a fucking auction. Make them slow down. They're going to act like it is an egregious intention to thwart their process and to slow it down. But he who pays in haste pays twice, ladies and gentlemen. Call the ball. Tell them to slow down. Make it a little retardando. Slow it down. Speak clairvoyantly so that all parties may comprehend what's going on. Are you pissing on my back and trying to convince me it's raining by speaking fast and using extravagant language? Or are you being forthcoming with your intent and trying to help me and the rest of these people, furthermore, comprehend and understand the law to make sure that we are all abiding by the law? Slow down. And again, they're going to say this is an attempt to slow this process down and to subvert from justice. And we would request that if he doesn't comprehend or understand, that he seek adequate legal counsel. The reason they want you to have one of their fellow brothers at the bar is because the first duty of the Bar Association member is to ensure that you don't have any appealable issues, that you waive all of your substantive and unalienable rights to know the full nature and cause, and therefore waive your right to appeal. All right? So be very careful of their trick, their little devils, of getting you to accept one of their fellow brethren at the bar. 19. Won't my answer depend upon how you define key terms? Contract creates the law and equity follows the law. Number 19 is a very poignant point. If we cannot agree on the definition or the key terms being used, the words, mind you, the jurisdiction, then we have no contract. If I speak Swahili and you're communicating me in Japanese and you don't read or write or comprehend Swahili and I don't read, write Japanese, can we ever have a meeting of the minds? Can we ever agree to terms and conditions? And the answer to that, ladies and gentlemen, is no. To be able to contract, we must all agree the terms and conditions must be mutually beneficial for all parties involved. There must be value and consideration exchange. There must be performance on both ends of both parties. Okay, and the terms and conditions must be clearly defined. Everybody must be cognitive of the condition they put themselves in. That's what creates a lawful and legally binding contract. 20. What? I am sorry, but is your question reasonably calculated to lead to the discovery of admissible evidence? Could you rephrase that question? These are things that you need to be able to ask at a moment's notice if clarity needs to be had. All right, and remember, questions that are reasonably calculated to lead to the discovery of admissible evidence in your request for admissions and your depositions are allowed. They may object to them, and you're going to, if the objection is sustained, you're going to object as and take exception to it as an appealable issue because the questions you're asking may reasonably lead to admissible evidence and therefore require them to go ahead and answer. All right. So during deposition, to find out whether or not they've been morally compromised, I ask all kinds of questions that most people, their skin would be crawling. But I ask them to find out, if they've ever engaged in moral turpitude. Where is their moral fiber? Where do they draw the line? Okay. Are they forthcoming, honest? Do they have any interest in the matter? Is it a chance that they're biased? Okay. Things of that nature. So I may ask if you've engaged in premarital sex. And that's a matter of moral turpitude. Have you ever cheated on your significant other? And I will remind you, you're under oath. If I do a little digging with a private investigator and find out that you have, in fact, cheated on your significant other, that is grounds for impeaching you. You are not a man or a woman of moral character, capable of providing your testimony before the court because your integrity has been called into question. You have purged yourself, and therefore your testimony is inadmissible. All right? So keep that in mind. 21. Do I speak legalese, or does this court speak a foreign language, a different dialect? Yes or no? What language is being spoke in this court? In America, the language is English, but you will find so often in court pleadings and documents they use French, Latin, legalese, and English. All right, and in order for a contract to be binding, again, it's got to be written in one language, okay? To ensure due process, may I ask a few defining questions? Terms. For the record, can this court take judicial notice that I do not know the law? Yes or no? This is a yes or no question. 23. Are you silently presuming that I know the law, Judge? Yes or no? Is it a presumption of this court and yourself, right? Because this court is really the judge's opinion. The man who has a title of nobility called judge is going to formulate a presumption and an assumption that you know the law, all right? Is there a presumption in law that anybody that comes before this court is learned in law? Yes or no? Are all men responsible for knowing the law because all men are responsible for knowing the contracts they enter into? And because of that fact, contract creates the law and equity follows the law. And as such, all men are responsible for knowing the contracts they enter into. Is that true? Yes or no? Is that the presumption and assumption of this court based upon maxims of law? Yes or no? How is it physically possible for me to read over 60 million statutes plus everything ever published in the Federal Register? Okay, there is a statute in all 50 states and federally that says all men are responsible for knowing what's on public record. Well, that's an impossibility. And if there's an impossibility, it grants no rise for the obligation of performance. Okay? So it's impracticable. It's an impossibility. And you don't have to know all those things, although they presume and assume by statute that you do, and that everything that is published on public record is, for and on the official record, known by all. And even the judge himself has not read the 60 million plus statutes of everything ever published. So he himself cannot even affirm that he knows these things. 24. Can you show me where the post office is lawfully authorized to serve process? A very good question. Okay. And you want them to provide where the law defines that the post office is lawfully authorized to serve process. Due process of law requires proper process of service. Okay. 25. Does the prosecutor have firsthand knowledge or mere hearsay? Is he a witness? Is he the attorney? Remember, the definition for an attorney is to turn property from one and give to another. Okay. And if he's going to enter things onto the record, well, then he must be a witness who needs to swear in before doing so. Okay? Is he a real party in interest or a third party interloper? Has he or she fabricated a scenario, okay, fabricated a alleged violation using simulated legal process and sham unsworn, unverifiable pleadings? Yes or no? Okay, this is grounds for a dismissal. 26. Swear yourself in and demand all others, prosecutor, do the same. They will absolutely fucking refuse to do that, by the way. It's funny to watch them run around. They look like ants underneath a magnifying glass on a summer hot July day. They just scurry around like they're on fire. If they refuse to be sworn in, then ask. Let the records reflect that these people won't swear in and probably intend to lie. Okay? To deny one thing is to admit 1,000 others, ladies and gentlemen. 28. May I see the charging instrument, the supporting sworn affidavits from each and every accuser, and the statement of facts in support of the verifiable claim. The charging instrument needs to be verifiable, meaning that I could take it to the Secretary of State and I could authenticate it, or it was signed by two witnesses willing to testify under the pains and penalties of perjury to the veracity of the facts so stated therein. Okay? They don't have any of that. Guess what? Grounds for dismiss for a claim for which relief cannot be granted. Insufficient pleadings. Okay? Simulated legal process. Sham legal pleadings. Okay? No claimant has made a general appearance sworn to independently bonding the claimant. I believe none exist. And for that reason, move this court. I know, move this court. Not motioning shit. I move this court to dismiss on those grounds. And if the prosecutor objects and gives some benign fucking reason as to why they wish to proceed, and the judge sustains the objection and allows it, well, then I object and take exception to it as an appealable issue, as I believe it's a palpable error at law. Under the Fourth Amendment, I have the right to face my accuser. Okay? Under the Sixth Amendment, I have the right to face my accuser. All right? And as such, I'm now being denied one of my substantive rights or unalienable rights to face my accuser, depending on how you want to word it. You can structure it both ways. Okay? And that you want that objection noted for it on the official record as an appealable issue for which you are taking exception to. 29. Don't I have the right to remain silent? Can anything I say be used against me? Okay, it's a loaded question. Remember, once you give testimony, cross-examination, you can't plead the Fifth Amendment. All right? Are you trying to coerce me into violating my rights to remain silent? Judge, if you are not going to protect my constitutionally protected rights, that's properly stated, by the way, they're constitutionally protected. It's not a constitutional right. They're constitutionally protected. It's contractual in nature. Rights. Shouldn't I expect you to recuse yourself immediately? Before I answer that, can you grant me immunity from state and federal prosecution? You already have immunity. Okay? 32. I don't know my name. I'm sorry. What evidence do you have that all caps name is my true name? All right? The name is nothing more than hearsay. Some people call me son of a bitch. Some people call me asshole. Some people call me brother. Other people call me son. Am I that name, or is it a descriptor and a depictor that I sometimes adopt and use? although I've been known to use that name, who carries the primary active degree of fault for that name? Who registered it? Who owns it? See, in a court case, you should sound like a fucking owl. Who? What? Where? When? Why? Who? All right? I don't recognize that as my true name, as me. This statement may be dangerous, okay? Instead, ask, who carries the primary active degree of fault for the name that I've been known to use? Although I use it, who owns it? Who's liable for it? Okay? 33. May I object to your use of the idiom sonum? The doctrine of idiom sonum is if it looks the same, it sounds the same, it must be the same. I therefore rebut and rebuke and reject the presumption and assumption that, as the doctrine of idiom sonum so eloquently states, if it looks the same, sounds the same, it must be the same. I reject that notion and theory, and it does not apply to me. I do not accept it under the legal principles of capitis deminatio. 34. I can't find a competent attorney for sentencing. Nobody would sign my contract. That contract is, instead I would ask the question, where do I find a competent attorney who is willing to swear under the pains and penalties of perjury that he will protect my unalienable rights and enforce the Constitution, even unto death? Where do I find a man of that caliber, of that status, that has that kind of standing? And you're never going to find one. Ever. Ever. In the field in disarray of attorneys at bar. You will never find one that will swear an undying pledge to you to defend you at all cost, even unto death. To protect your unalienable rights and enforce the Constitution, the law of the land. You will never find one that will be willing to do so. 36. How can I make a legal determination on the validity of what you are asking me to do? Where's the finding and facts and conclusion of the law? Where's the contract that I knowingly, willingly, and intentionally entered into that binds me to such obligation? 37. Don't you need my permission to do this? Okay, yes or no? Do you need my consent to move forward? Yes or no? Do I have to volunteer? Yes or no? Is involuntary servitude illegal and unlawful? Yes or no? Is coercion illegal and unlawful? Yes or no? Okay? Don't I have to consent? Yes or no? 38. If you don't need my permission first, why did I have to sign the citation, order, or contract? Okay? If you don't need my consent, if you don't need evidence of my consent through coercion and via its arms, if you don't sign, you're going to jail, right? They presume and assume that you entered into the contract freely of your own free volition and not under coercion and distress, right? You weren't threatened to enter into any agreement. They ask that at every court. And yes, as a matter of fact, there was a gun-toting moron with an IQ of 70 that was armed via its arms and said, you sign or you go to jail. So yes, I was coerced. Yes, I was threatened. And go all the way back to the beginning. 39. That is not my signature. Okay, that's a statement. You got to prove that now. Where the underlying presumption of this contract disclosed to me, were the underlying presumptions of this contract disclosed to me, was full disclosure had the nature and cause and all the elements of the contract. Where is the mutual assent of the mind and the mutually beneficial binding agreement between all parties? Because a contract requires two consenting people of age of majority, both bound by performance, who agree to something. Okay, and it must be written in plain language under the plain language doctrine. Otherwise, it's void for vagueness under the void for vagueness doctrine. In order to understand the legal language, please provide me with a Black's 4th edition law dictionary. All right, now, You could be more extensive about that. For example, nowadays they want you to play their game electronically. Well, if you wish for me to do things electronically, I need you to provide me a brand new Dell laptop. I need electricity that you will provide, and I need internet that you will provide because he who provides the ends must provide the means. So if the only way I can communicate with your sinister fucking organization is by electronic means under the Paper Reduction Act, dickhead, then you, I mean Richard, then you are expected by the maxims of law, nature's God, all right, natural law, to provide me the means to do so. You can't expect me to perform an impossibility. So he who provides the ends provides the means. So whenever you can get those resources to me, remember it's got to be convenient for me. They can't just say, "Well, you can go to the the public library and do all this bullshit." Now that borders involuntary servitude, slavery, peonage, bondage, all that crap. By compelling me to go perform, or trying to get me to enter into an agreement, a contract that I'll go down to the local library. No, 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 no. You're gonna come over to my house, pay the electric bill. You're gonna come over to the house and zero balance the internet bill. You're going to come over and bring me a brand new laptop. You're going to give me access to all the law libraries throughout the country, including the Library of Congress, so I can go find my perfect defense. All right? And for my perfect defense of your willful, wanton disregard of the law. 40. How am I liable for the sum in controversy? Well, you have to understand the monetary system a little bit to understand that question, but make them answer it. Title 18, subsection 8, all obligations are obligations of the United States. And when I say all, I mean all, A-L-L, all. But that's not the law. Where is the law that says that all obligations are obligations of the United States? Well, ladies and gentlemen, I implore you to look at the 73rd Congress, Volume 77, Part 1. 1,164 pages of it. Go read it. I think you would be enlightened to see where the law is found and what they're bound to do. 41. Could this court define lawful money? And they could, but they won't. How can I lawfully pay a debt with a debt? I'll agree with your order to pay alleged debt so long as this court, the judge, and all parties involved acknowledge and accept Article 1, Section 10, or so long as the order is compliant with the law of the land under Article 1, Section 10. They'll dismiss the case immediately. Put the Federal Reserve note on trial. In what form of lawful money credit is payment, obligation, due? Okay. What specie won't you accept? I like to put it in an impossible question. Okay. What won't you accept for payment? Or I can ask, what specie? Be specific. What specie must I use in order to remedy the subject matter before this court? What specie? They'll never say it because it's a violation of public policy. It's a violation of the Constitution. They would be engaged in mixed war, so on and so forth. Your Honor, how do you propose to collect? Asking that question, now it's an attempt to collect the debt. Falls under consumer protection, Title 15. Truth in lending, all right? Things of that nature. Where do you have my promise to pay? Okay, where is that promissory note? Where is that bill of exchange? Is the citation a security? Okay, is it being negotiated? Have the funds already been transferred from the United States Treasury? Are they in constructive possession of the security and the financial wherewithal to offset and discharge the matter and are failing to do so, and in as much as one can offset and discharge, do they have contempt for the law by misappropriation of funds, leading you to believe there's another way to offset and discharge? Are they stating that they have contempt for 40 statute at large 411 and contempt for Congress, where they are not fully acquitting and discharging the matter dollar for dollar? Okay. 43. Is it lawful for the state to demand anything from me other than gold or silver coin? In all state constitution, it says the only way to tender a payment for debt is in gold or silver coin minted by the United States Mint. That's the law of the land. And lawyers will argue that has all been changed. Not on the de jure side it hasn't, because acts do not amend the Constitution. In fact, it is extraordinarily hard to amend the Constitution, and acts do not amend the Constitution. So that might be a question that you ask. Can acts amend the Constitution, which is the law of the land? Yes or no? And the answer to that is no. Here's another key to all of this. Don't ever ask a question you don't already know the answer to. If you do, then how could you object and take exception to it as an appealable issue if you don't know the answer to the question that you're already asking? All right. 44. Don't the legal tender laws only apply to debts founded on a contract? And again, you're going to find your answer in 40 Statute at Large 411, Trading with the Enemy Act, page 418, section 7E. Are judgments and taxes founded on contract? Yes or no? Please take judicial notice that there is no gold or silver coin in circulation. This is true. It is impossible to pay. How can the law require the impossible? Clearfield Doctrine. 45. Judge, why are you asking me questions? Is it not the judge's job to be a referee? If the judge has to ask clarifying questions, then obviously the plaintiff has not met the burden of proof beyond a reasonable doubt, and therefore this court must rule in my favor and dismiss. Okay, the onus of probandi is on the moving party, the plaintiff. And in their failure to explain their juxtaposition with great clarity, the man on the bench is now asking you questions to incriminate yourself. He's practicing law from the bench. Okay? He's attempting to assist, aid, and abet a claim made by the plaintiff. If he doesn't understand the plaintiff's claim to the degree that he has to ask you to clarify the plaintiff's juxtaposition, well, then this case should be dismissed. Clearly evident by the fact that the man on the bench is asking qualifying questions or clarifying questions to get the defendant to incriminate themselves. And as such, the plaintiff has not met its burden of proof beyond a reasonable doubt, and therefore grants rise to move this court to dismiss for a claim for which relief cannot be granted. Isn't my accuser supposed to be the one to ask me questions? Yes or no? Are you, Judge, my accuser? Yes or no? Are you practicing law from the bench? Yes or no? 46. Mr. United States Attorney, are you an organic part of the Federal Justice Department? Okay. Where is your SF-61 on file? All right. I'm going to subpoena it if you won't voluntarily bring it in for my inspection. Where is your oath of office and your bond? Okay. 47. 46 goes to standing, ladies and gentlemen, so you understand it. It's about standing. 47. Are you prosecuting me upon your own personal recognizance? Or did somebody authorize you to do it? Where's your warrant of attorney? Where's your delegation of authority? Who is indemnifying me if these claims are found to be false, misleading, untrue? All right. Who is going to make sure I am made whole? Right? 48. May I ask if this prosecutor is a competent witness with firsthand knowledge? This is a very important question. First of all, a witness is a fiction, but a man with firsthand knowledge, now that's a good question, all right? Because if he has firsthand knowledge, ladies and gentlemen, well, then you need to subpoena him as a witness, and he couldn't possibly be a lawyer or attorney for the opposing side, could he? But if you don't make the issue, you waive the issue. And this is grounds for an appeal, by the way. Everything I'm really talking about is grounds for an appeal if you structure it proper. If he is not, for the record, may I order him not to speak, as he only has hearsay, and I wouldn't even go as far to call it evidence, as everything he says is hearsay. He's not been qualified as an expert. Everything he has to say is hearsay. He's barred from entering evidence onto the record unless he wants to swear in under the pains and penalties of perjury. And if he opens his mouth, it will be contempt for this court and contempt of the law. Do we have an agreement? Do we have an accord? Okay? If he is he an interloper, a disinterested third party trying to profit and gain from this artifice and scheme, this simulated legal process using sham legal pleadings? Okay? Using a false and fictitious name, sending threatening correspondence via the mail. All right? And this is all stuff your sheriff is supposed to be keen to as well, so he can hold these people accountable. Okay? This is something all your sheriffs should know, all this shit. So when they're in the court witnessing this stuff, they can arrest these people and bring charges against them. And they can go in and complete a sheriff's inquiry. It's amazing to me that of all the sheriffs and sheriff's deputies I've ever spoke with, none of them have ever heard of a sheriff's inquiry. And it blows my mind how ignorant of the law these people really are. I don't know the answer to your question, but I will go talk to an attorney. Oh, that's a good idea. Let's go talk to the rats in the woodpile and find out what their consensus on the subject matter is, instead of going reading a book and figuring it out for themselves. 49. Where is the victim? Who is the real party in interest making a claim for which relief can be granted? Standing, ladies and gentlemen. If you don't make the issue, you waive the issue. Do not make that mistake. If they object and say, that's not relevant, Your Honor, speculation, outside the scope of the authority of this court, blah, 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 and it is sustained, or, they agree with the plaintiff's attorney, then you object as an appealable issue and take exception to it. Okay? They're well outside the law. You want a finding of facts and conclusions of law on how they made that determination. If they won't provide that, then you also object to that fact and take exception to it as an appealable issue as well. You're setting up your perfect affirmative defense at the appellate level. Where's the first-hand eyewitness? Okay? Have the right to face the accuser under the federal Constitution or the Sixth Amendment, the more perfect union that was formed through the Union of States. And then you have the state constitution, which I would implore and invoke and employ as well. And in the state constitution, you will also find where it provides that you have a right to face your accuser. Where is a competent accuser? Where's the man that is going to take the stand that I can cross-examine, okay, or depose under oath? Where are they? That way you can separate fiction and reality, oil and water. They don't fucking mix. Judge, can you have this peace officer sign a document waiving his immunity in this case in case he lies? Well, immunity is a joke, and here's why. Because if there's alleged immunity, then there is not equal protection of the law. And the law applies to everybody equally, or there is no law at all. So there's no such thing as immunity. All right? And of course, they're going to say, no, he's not going to do any of that. He's not required to do any of that. Blah, 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 blah. I object and take exception to it as an appealable issue. All right? The officer and the court will deny the request. How will this look on review if he refuses to waive the immunity privileges? Privileges are something granted by an organization or a society of people who all agree to a social compact, right? That's a privilege. Privileges are like your dad giving you the keys on a Friday night for a hot date, and he gave you some chores to do through the week, but you didn't do them. You haven't figured this out yet. I'm speaking about myself. And all of a sudden, Pops decides, well, you didn't do what I asked. So privilege granted is privilege also revocable. And I am now taking the keys to the car. And I don't care about your plight about how good looking this lady is. You don't get to go on your date, Scooter. Better luck next time. All right. That's a privilege. A right is something that is granted to you by a higher authority that cannot be removed by any man on this planet. That's a right. A privilege can be removed, all right? So the privilege of immunity is a joke. It's laughable because you're not part of that society. Remember, you have the right to self-govern. Won't your testimony be surely construed as tainted? Tainted, right from the taint. It's not quite the asshole, and it's just never mind. I have to be kid-friendly. Taint quite asshole, and yeah, never mind. I'm so confused. All right, I'm confused. Why else would the officer refuse to waive his immunity unless, of course, he was going to lie? All right? The rebuttable presumptions, okay? The 12 presumptions of law, the presumptions of residency. All right? We have to rebut and rebuke all of these things. And let me tell you, for and on the official record, they're all allowed to lie to you under the wartime military manuals. Under Admiralty maritime law, they are allowed to lie to get what they want. They're thieves in the night. Foxes guarding the hen house, eating chickens with feathers all over their face, swearing up and down that they won't swear, but you can believe us, we're not eating chickens. And meanwhile, there are feathers everywhere. The evidence is undeniable to those of sane, sound mind. 50. The info on my birth is hearsay, and you won't admit hearsay evidence into this court, right? Okay? And a true judicial court, hearsay is unacceptable. It's not allowed. They only want what's true, correct, accurate, not misleading. In administrative procedures, through the administrative side of the alleged court, they'll allow all kinds of hearsay. Okay? 51. What is the federal tax identification number of this court? If they have a federal tax identification number, ladies and gentlemen, they're engaged in commerce. Proves court is a corporation. All right? It's not de jure. It's defunct. All right? It's de facto. It's business. Your Honor, are you a Mason, a Freemason? It's among the general consensus that most of the judicial people sitting on the bench are part of some type of organization. These organizations known as like the Freemasons, the Illuminati, and so forth, all have private membership oaths that they have to take. Is your oath to the Freemasons in conflict and contrary to the oath of the Constitution for the United States? If so, this is clearly a perpetual conflict of interest, and as such, you must recuse yourself. Officers, like Sheriff's Department and police officers, also participate in the Freemasons. And so you want to ask those questions as well of the prosecutor and the police officer. And if so, they have to recuse themselves because there's a conflict of interest here. Okay? They're not supposed to have an oath to any foreign agency, army, guerrilla warfare type organizations, or even something as simple as the Boy Scouts of America. okay, that seems honorable on its face and very well may be, but that is in conflict with their oath to the Constitution of the United States of America and the Constitution for the state that you're in. Your Honor, are you a beneficiary or an associate of any of the inns of the court? All of these courts are directly tied back to the inns of court over there in Europe. All right. 54, excuse me, can you show me where your judge's office was created by law? Need a finding of facts and conclusion of law. Show me where your judge's office was created by law. 55, isn't there a statute that says the clerk shall record all records? Yes or no? I order this case dismissed. Okay, or move this court to dismiss this case. That depends, Your Honor, on how do you define understand. Do you understand the allegations and charges brought against you? Well, let's get some clarification on the word understand. Okay, I don't understand equals I do not come under your standing, judge, court, a contractual agreement. That's how easy it is to get an oral contractual agreement under the presumption and assumption that you comprehend the words being used, all right, which creates joinder in a contract. 57, I conditionally accept your offer for value upon valid proof that you can verify that claim. Means that you're going to voluntarily come into open court and prove your claim. 58, Your Honor, are you a public servant? If no, then whom, sir, do you serve? All right? You don't serve the public, then who do you serve? Do you serve we the people? Because the connotation about the public may not be what you think it means. So we might need some clarification on what public is. Okay, is public a corporation? Or is public we the people? Okay? 59. May I see your state-issued license to practice law? This doesn't exist. It's a joke. It's a funny thing to ask them just to watch them squirm. Here in Washington, is a bar card a license? Yes or no? Let's see if they're going to be honest. And if they say yes, then I need a finding of facts and conclusions of the law. Where did you find that information at? Okay? What law allows any private nonprofit organization to issue a state license? Is WSBA a closed union shop? Okay, so that would be the Washington State Bar Association, WSBA. I put that together because the document was clearly created utilizing the state that he was familiar with, which is Washington. Okay? 60. Scroll up here. May we cut to the chase here? What is the purpose today? What would this court want from me? All they want is your assent. They want to get paid. They want you to endorse the instrument properly so they can take the security and negotiate it and get actual cash value for your signature. Okay? I will be glad to comply if you, judge, will just sign an order compelling me to perform. They're not going to sign an order for you to perform because he who orders something has to pay for it. So they won't do that. I know this with firsthand perfected knowledge. 61. I would like to answer that, judge, but I must defer until I get competent assistance of counsel. Notice it doesn't say a competent attorney because there are no competent attorneys. There are only lying, looting, pandering shit breaks that allege to be attorneys. Okay? There are no competent assistants of attorneys because they all work for the bar. They all work for the inns of court. They're all bound by a private oath they take to their fellow brethren and society for which they've joined that you are not privy to. Okay? 62. Is this case civil or criminal? If it's criminal, where's the injured party making a general appearance before this court sworn to independently bonding the claim? Okay? If it's civil, produce the contract that I knowingly, willingly, and intentionally entered into that wasn't written with vague and ambiguous language or any blind adhesion contracts. Then shouldn't we go by civil rules here? If it's civil, then we operate by civil rules of procedure. And if it's criminal, by the criminal rules of procedure. If no, ask based on what? May I let the record show that, repeat, the gist of the question above. Options. Get a certified copy of the judge's oath and file it into the case to lock him in. I go above and beyond that. I do judicial notices, and I go and I find their oaths, all the oaths they're supposed to have, provided by the legislator, the Congress, and the constitutions, and I write them all down and I supplant their name in it, and I do an acknowledgement and acceptance of all of their oaths of office. Okay? So I hope this video helps you out in your endeavors, helps you ascend to the mind, share it with your friends and family. Of course, as always, keep your shit wired tight, your head on a swivel. Let's keep it styling while we're low profiling, ladies and gentlemen. God bless and Godspeed, and we'll talk to you soon. Thanks again for all your support at selfgovernanceu.com, and for those of you who attend classes that give me the ability to bring this credible information to you for your viewing and listening pleasure in your busy, chaotic life. Until we meet again.